But I believe the focus of the mootness is here is in the planning of what occurred. We're not saying that.
But the timing is irrelevant, isn't it?
I don't think it is, Your Honor. There were thousands of documents, including this document. We recognized, and the procedures had been changed. Those procedures, which of course would give rise to the ability, if you violate your local procedures, the courts have even said that in the Sunshine Act context, that matter has been cured. Now the question becomes, and it's really, I submit to Justice Kahn, not a matter of just good faith. It is a matter of procedures that have been changed and a mistake that has been made, and now you're seeking.
And I appreciate that. I guess I'm trying to focus on. I'm not arguing with you necessarily. I'm just trying to ask for us to agree with you. It seems to me we essentially have to hold beyond the facts of this particular case, whether we're right or not. We have to make a decision that, well, you cannot get a declaratory judgment regarding a legal matter if the other party waves the white flag and says, we surrender.
No, Your Honor, if I said that, I misspoke. First of all, you can get declaratory relief if the underlying question is, was it a public record? That happens with great frequency. In the most recent case, the athletics case out of Florida State, as you recall, the issue was not whether it could be disclosed. The fundamental issue was, is it a public record? That happens all the time. What I'm simply saying to you that happens under Chapter 86 is you have to have before you a controversy, meaning that one party has to be...
But I'm going to suggest to you that Judge Thomas has capsulized it, because we're not litigating about whether it's a public record. And why isn't his suggestion true, which is that, oh, if the body that's subject to the Constitution comes forward after the fact and says, oh, we made a mistake, it's a public record, the case is moot. I'll be honest with you, that doesn't make any sense at all.
If you had answered the question, if the original pleading was isolated to this case, our answer would have been, in a responsive pleading, that it was a public record.
But we are not litigating the question of whether the minutes were a public record.
They are.
The body agrees to that. What we are litigating is whether someone who is denied a public record and given that public record at a time when it's of no use to them is denied access to courts because the court's moved.
Well, it certainly was of use to them because it was central to the employee decision of this court. But backing up, what you're saying is, and let me kind of put the other view here. What you're saying is that if you make a mistake, that mistake which you readily admit that occurred, one that after the fact we've had there's complete litigation regarding, that months later you're entitled under a 119 claim and a Chapter 86 claim, you're entitled to relief for which, A, no one's controverting that the mistake occurred, which goes to the justiciability under Chapter 86. We're agreeing that a mistake was made. No one's contending that that mistake was not made. You're seeking fees and costs saying, you can't be under 119 because Nunez says you had the record and you had it for months. You can't be...
Chapter 86 requires that a plaintiff be able to state a case, a true case, that he or she or it is in doubt about his or her rights under a provision of law or perhaps a provision of a contract. This almost is a classic case of this, where a city functionary has violated the Constitution. You all as the lawyers admit that, and they're saying, hey, we're in doubt about what's going to happen the next month.
But that's what I'm saying, Your Honor. There can't be a doubt when in fact what your answer is that a mistake was made. Mootness applies to Chapter 86.
Are you stipulating we should enter an injunctive relief?
Not at all, Your Honor. To enjoin what? To enjoin a procedure that's been changed.
Violations of the statute which you have admitted your client violated.
To enjoin a procedure that has...
We don't know that, counsel. I appreciate it. You're an officer of the court, but we don't know that.
Well, Your Honor, the record that this court has before it is the trial court record. The trial court record said, to make it very clear, we have not controverted, did not in the hearing, did not at any point controvert that the failure to give those minutes that night was a violation of the Public Records Act. It was. This is about January of the next year. Do you now get to sue us something that can, if you will, retrospectively be cured? No one's needs it. We don't need, what is the need of declaratory relief to say?
Counsel, it seems to me that this issue has pretty serious consequences now, because public records law, as we all know, is a factor that can be difficult to enforce, difficult to follow. It's, it's a complex statute in practice at times. So it's going to, mootness has an element to it that it's an issue that's not likely to recur, which I believe Judge Cohn's questions may be getting to, which is, it's not just your client. It seems to me that might likely, you know, A, will either never do it again, or B, didn't do it, admitted their fault. You seem to be arguing that under Chapter 86 in the interface with 119, that when governmental bodies violate 119, a trial court really doesn't have the authority to enter a declaratory judgment after the fact, where the body admits the mistake and issue an order that says, you violated 119, I so hold, and I award attorney's fees.
Well,
That's the rule I think you're arguing.
to a certain degree, that's true, Your Honor, because here's the issue. Can a body which has made a mistake, admittedly made a mistake, has not provided timely a record, we know the record was provided. So we know that the 119 aspect of filing the
Was it
lawsuit.
provided by your client or a third party? I thought the allegation was they obtained it from another.
And this court found, and on that binding, on that you would be bound. This court found that, in the court below, that in fact we provided it. So let's set aside for a moment that's not an issue. It was provided prior to August. Now what you're asking for is we want declaratory relief to say that you're not providing it in a timely fashion back in May was a violation of the Constitution. The problem is we don't controvert that. It was in fact a violation. What you're suggesting, or to go the other way,
Counsel,
you're suggesting that this becomes a
I
gotcha.
appreciate your vigorous advocacy, but the only logical extension I can see to your argument, y'all can do this tomorrow and then turn around a day after the next commission meeting and give them the document. And it's moved again. And then you do the same thing the next month and the next month. I'm not saying that's your intent, but it seems to me like you are skipping that part of the argument.
And all I want to say in response to that, Judge, is as that would have this court ignore the findings of the court below, that there were thousands and thousands of requests that were met, that there were thousands and thousands of
But there
requests.
is not an issue in this case of undue burden or hardship. If that had been the defense, perhaps we'd have a different case here.
Well, absolutely,
This is
Your
a
Honor.
specific document. I don't know how long these minutes are. I don't recall, but it's not very good.
But they're very small. Your Honor, what I'm contending back to you is I think that you have to look at the context of the case. In the context of the case, I think the court found in part, wait a second, on this a deputy clerk made a mistake not providing it, but there's certainly not, as you would suggest, that suddenly we could correct it every time by simply saying, we don't give it to you now, we'll give it to you later. That would be a different case than what happened here. On one occasion, a mistake was made. That document was provided by the public body months before the lawsuit. The public body came and admitted error on that instance. Now remember, in the context of this lawsuit was about many, many other issues. But in the context of this lawsuit, the court said, all right, here's my analysis. Number one, the consent agenda, you don't have to do anything.
I think your time is
It is, Your Honor. I apologize.
I do appreciate the vigorous advocacy in this case.